Sorry, I was cracking myself up at that dog clip. Hi, everyone. How are you doing? I know it's late, but I wanted to catch up on all the legal cases I'm doing so that maybe I could get back to some straight political commentary. But this is a really interesting one. So let me do the YouTuber stuff if I can find my little screen here, and we'll get right to it. So subscribe. There's a chance right there below, and I'll probably remember to stick an end screen on. And also you can follow me on Twitter at Karen Ann Harlos. My Twitter's been fire lately. And last but not least, certainly, I would really appreciate it if you would subscribe on Patreon at patreon.com/Pink Flame of Liberty. There is some subscriber-only content. Okay, we're going to get right to it. I'm going to put up here, if I remember, the playlist. I think it's only got one or two other videos on it at this moment, but for this Melania Trump case. So let me give the brief background again. If you didn't watch the prior one, we won't get into great detail, but a reporter from the Daily Beast, he also does some other journalistic work, Michael Wolff. He's also the one who had the interview with Jeffrey Epstein, so his name's been in some emails, not as implicated, but as a reporter. Well, he made certain allegations against President Trump and Melania Trump. Melania Trump is a lawyer, Florida-based lawyer, that will be important, sent him a demand letter demanding a retraction and basically saying, if you don't do this by a certain date, we're going to sue you for $1 billion. So Michael Wolff thought he'd be cute, and he ran to the courthouse first and filed a motion to kind of cut her off at the pass. He filed for a declaratory action. Watch the earlier video if you want to get more into the legal details of what that is. Then it got removed from state court in New York, because it was filed in New York, to the Southern District of New York, which is federal court. This is where we're at now. And Melania Trump, obviously through her attorneys, but Melania Trump has filed a motion to dismiss as expected. I want to front load this with my conclusion, my opinion. Remember, I'm not a lawyer. I am a paralegal, not a lawyer. Nothing I'm saying should be interpreted as being any kind of legal advice or licensed in any sense whatsoever. Okay, with that disclaimer out of the way, I'm going to front load this with, I think she's going to win the motion to dismiss. And I think she should win the motion to dismiss. That's not going to stop people from saying that if there's a Trump name behind something, I'm going to automatically not be on their side, if that's even a thing. No, this is just sheerly on the legal merits. I'm not impressed at all with what Michael Wolff did. Not at all. Now, if Melania does end up suing him for defamation, that's an entirely different ballgame. I'd need to look at it then. But this declaratory action, I think her legal arguments are correct. I also think he's correct that it was just sent to intimidate him, and she has no intent of ever suing him, and probably will not now. So even though legally, I think he's raised like $800,000 already, that's mentioned in here, towards his legal fees. So perhaps it was a clever legal strategy to make sure she never does sue him for defamation. But in any event, let's get to the motion to dismiss. Again, this is kind of legal geekery, okay? But if you're into that sort of thing, that's what we're going to do. So, like most cases, I print them out. I'm old school. It's all the the table of cases, and there's a lot of cases cited. This is actually a well-written motion, I think. I wasn't too impressed with the filing so far. I don't know who filed this because a new attorney entered an appearance. That's when an attorney tells the court they're also you can have multiple attorneys representing one party. And I don't know which one filed this. It's the new guy. Josh Halpern of DLA Piper in Washington, D.C. I thought the writing was different. I like this one. Okay. So we're going to read the pertinent parts so you get a flavor of what is going on. Why not? You always, yeah, you always want to get a flavor of a court case. Is this spicy? Is it sweet? Okie dokie. First Lady of the United States, Melania Trump, Mrs. Trump, respectfully submits this memorandum in support of her motion to dismiss this action, though. These are the reasons why she says it should be dismissed. Insufficient service, true. Lack of personal jurisdiction, I think they're correct. Failure to state a claim pursuant to federal rules of civil procedure, and they named the rules. I think that's correct. Or in the alternative, to transfer this case to the United States District Court for the Southern District of Florida. And if those other things are denied, I also think this is correct. I think this is a winning motion. So here's part of the preliminary statement. Ban letter was sent. Rather than comply with that demand, and of course, here's the attorneys like to get all lathered up and use colorful language. Plaintiff raced to see Michael Wolff raced to New York State Court to file this facially improper declaratory judgment action, which seeks a preemptive declaration that plaintiff is not liable to Mrs. Trump for defamation, and a prospective declaration that Mrs. Trump would owe plaintiff attorney's fees under New York's anti-SLAPP statute in a hypothetical, unfiled defamation suit. The complaint is entirely lacking in any legal basis and should be dismissed on several grounds. If you do go and watch my prior video on this, of course, the lawyer did it way better than I ever could, but I basically made the same philosophical arguments that this was just a completely improper declaratory action, where I said they were seeking from the court an advisory opinion, and you'll see those words come up here in a motion to dismiss. Mama knows a little bit about this kind of stuff. Again, not an attorney. And so they're trying to serve her in New York and claim she's a New York resident. She is not. So plaintiff improperly attempted to serve a doorman at Trump Tower in Midtown Manhattan and Mrs. Trump's counsel, neither of whom is authorized to accept service on Mrs. Trump's behalf. The complaint should be dismissed on this basis alone. Now, I watch shows from all perspectives. I watch some right-leaning shows. I watch some that claim to be centrist, whatever, independent, and some left-leaning shows. And I probably am going to be doing a clip of this at some point, but there was one left-leaning show or leftist show, however you want to put it, that was really mocking, it might have been Midas Touch, but was really mocking, oh, her attorney won't accept service. Like it was some kind of weird, sneaky thing that she was doing. That's really typical. Attorneys, just because someone is your attorney or sent out a demand letter for you, doesn't mean they're authorized to accept service of process for you. And what was being said on this show, and I don't want to mistakenly say it was Midas Test, I think it was, but I could be incorrect, was, oh, well, the demand letter said direct all communications to our office. But when Michael Wolff tried to serve the complaint, it got rejected. A communication is not a lawsuit. That obviously meant any communications and working out the terms of this demand letter and coming to a compromise, not service of process of a lawsuit. That was wrong to mock her for that. And believe me, there was something to mock. I'd like to, but I'm not going to be untruthful or unfair. Okay. says the sole purported basis for the jurisdiction in the complaint is Mrs. Trump's Florida-based counsel's email transmission of the October 15th, 2025 demand letter to plaintiffs. So yeah, they're claiming that like that invoked New York jurisdiction. I'm sorry, things don't work that way. That is such a stretch. Like, did you strain a muscle there? To hail a now, I don't agree. I don't really have an opinion on the defamation case, and of course, her attorney's going to state it, presuming that she's correct. That's just the way legal filings work. To hail a defamation victim into the alleged home state of the tortfeasor. A tort, like, that is like a civil infraction, like breach of contract is a tort, personal injury is a tort. A tortfeasor is someone who commits a tort. Defamation is a tort. So the alleged home state of the tortfeasor, based solely on the victim's demand for a retraction of the defamatory statements, would not just violate traditional notions of fair play and substantial justice, it would be a complete perversion of justice. Finally, plaintiffs attempt to obtain a preemptive declaration that he is not liable to Mrs. Trump for his past defamatory statements is an abuse of the declaratory judgment mechanism, which courts have uniformly rejected as improper. I gave like the layperson summary of what like a declaratory judgment is. It generally occurs in contract law, though not exclusively. My past experience has been in insurance defense, and that's where I would usually see it. So there would be a dispute or a potential dispute with the insurance company and the insured over the terms of the policy, and the insured would seek an interpretation of this contract. That's the context I've mostly seen it in. There isn't even an action yet. In any event, just to give you some background there. So we should probably like let me look up to see, because I'm just giving you like my experiential definition of a declaratory judgment. Let's see what Dr. Google says. A declaratory judgment is a binding court ruling that clarifies the legal rights, duties, and obligations of parties in a dispute, resolving uncertainty without ordering actions or awarding damages. Often used proactively to prevent future lawsuits by defining relationships under contracts, insurance policies, or property matters before a full-blown conflict erupts. It's a tool for early dispute resolution, allowing parties to seek judicial interpretation of uncertain legal situations like contract validity or patent rights to avoid escalation, and it carries the force of a final judgment. So it's interesting that they brought up insurance policies, because that's where I'm familiar with it. I've never heard of it used pre-defamation suit. Plaintiffs' claims for declaratory relief further improperly request advisory opinions. That's exactly what I said. That plaintiff would not be liable to Mrs. Trump for defamation, and that Mrs. Trump would be liable to plaintiff under New York's anti-SLAPP statute in a hypothetical future litigation of Mrs. Trump's defamation claims. This action is fatally defective on any of these grounds, but if the court does not dismiss, then it should be transferred to South Florida. Okay. She accuses Michael Wolff of forum shopping in service of plaintiff's broader goals to generate publicity for himself and profit off his harassment of Mrs. Trump. I don't agree with that. I mean, she sent him a threatening letter. He's a journalist. Okay, that doesn't mean they're completely immune from defamation. Again, not getting into the merits of that, but I don't think that statement there is fair. I don't think he would have went to court and used it for publicity, but for her sending him a demand letter. Of course, she could say, I would not have had to send them a demand. I can't say it in her voice. I can't do that accent. I would not have sent him a demand letter if he didn't defame me. So, whatever. As clear evidence of his bad faith intention to use this lawsuit as a publicity stunt and for-profit venture, plaintiff set up a GoFundMe page to fund this lawsuit that has raised nearly $800,000 as of this writing. Attorneys aren't cheap. I don't think necessarily that statement's very fair either. Okay. Let's see if there's anything else super interesting here. I think there was. And it says, as of this date, she still hasn't been served with the complaint. It says, on that basis, it should be dismissed. That one, I think, is the weakest one. What I think is the strongest one is failure to state a claim upon which relief can be granted. But here's where they're talking like the big miscarriage of justice. And I actually do think it would be if they said there was personal jurisdiction in New York. The exercise of personal jurisdiction under the circumstances here would be a particularly perverse outcome, given that in a defamation case, the defamatory publication itself cannot be the transaction that establishes jurisdiction in New York. And they're citing case law here that I'm skipping. If an out-of-state defamation defendant cannot be subject to personal jurisdiction based solely on a defamatory statement directed into New York, then it cannot be that an out-of-state defamation victim subjects herself to jurisdiction simply because her out-of-state counsel sends a letter demanding retraction of defamatory statements to an alleged New York resident. What I find really strange, though, that they do, what I found with attorneys, and either one, not one isn't right or not correct, but I found the conflicting styles jarring. Like normally stylistic choices you won't even notice because they're consistent, but because it switches up, it takes me back. Now that could be tactical, but for instance, as I said, where unequivocally declares her a victim. Some attorneys would soften that and say alleged or, terms to that effect, claims. But every time they mention her, it's like definitely this, definitely that. And when they mention him, like you noticed here, I found this jarring. Was it this page? Yeah, to an alleged New York resident. Is there really any question that Michael Wolff's not a New York resident? Like, it just alleged? That was just strange. And in the very beginning, when describing him, I want to try really funny. They said he's purportedly a journalist, and I didn't know if that was like some kind of backhanded slap. They did that in an earlier filing too, and yeah, you can do that, but it's normally, if you're going to use purportedly, allegedly, you do that consistently for all of the claims. In my opinion, which is, a lay opinion, I think judges like that better. I don't think judges really care for the chest pounding in the you know what I'm saying. But, whatever. Some like to do that. All right. So I don't think it's a dispute that he's a New York resident. Okay. And it says, courts uniformly have held that a declaratory judgment claim may not be used by parties who seek a declaration of non-liability to preemptively defeat tort claims already accrued by past wrongful conduct. So his alleged bad acts had already been done, and then after the fact, he wants the court to say they're not bad. Normally, a declaratory judgment is ahead of time, that parties are uncertain of their legal relations. It says, plaintiff improperly requests an advance ruling on a presently unasserted claim for defamation. So while a demand letter was sent, there's been no legal claim in court. It says, request a declaration, not yet. Yeah, we already said that. Count 2 should also be dismissed. It's the one that says she would be liable to him for anti-slap fees. And it says that statute explicitly limits relief to a defendant in an action involving public petition and participation against a person who commenced or continued such action. And they bolded the word defendant, and they said clearly plaintiff is not presently a defendant. I thought that was a really good argument. It's the plain reading of the statute. Plaintiff cannot use the New York statute offensively to obtain a declaration that Mrs. Trump will owe him damages in litigation that has not yet been filed. Good argument. I think that's the strongest. And then they go on to argue where if the court doesn't find any of that persuasive, it should be transferred to South Florida, which I also think. I think it's going to be dismissed anyway. I don't think it's going to be transferred. But if it's not, I think those arguments are strong as well. Okay, everyone, that was quick. I wanted to get this out to you. Hopefully you found it interesting. I appreciate your eyeballs on this, and I will keep track of it and keep you posted. Hope you have an awesome night. Bye-bye.
You gotta take what you're given, that's how we live it. Don't be mad at the system, it's simply how we've existed. I hear a lot of people talking like they politicians or choose to be an accountant because it's safe in the business.